Thanks so much for tuning in. This is attorney Matt Wayman here today to chat with you about orders of protection in Missouri. There's generally two types of orders of protection that we deal with. One would be an adult order of protection. This is an order stating that one adult should stay away from another adult. The second type is a child order of protection, and this is generally a parent petitioning on behalf of their child to have an adult stay away from their child. For the purposes of this video, we're just going to be dealing with adult orders of protection. The first thing I want to talk about in regards to orders of protection is the parties. The petitioner is the person that files the petition for an order of protection. This is the person that is claiming that the respondent committed some act of domestic violence or sexual assault or stalking against them. The respondent is the person that actually gets served with a copy of the order of protection, and this is the person that is alleged to have committed the act of sexual assault or domestic violence or stalking against the petitioner. The second thing I want to talk about is who can apply for orders of protection under Missouri law. Anybody that's been a victim of sexual assault or domestic violence or stalking has a right under Missouri law to ask a court to issue a full order of protection. They will file this petition with the court. The judge will then review this petition. If the judge finds the allegations credible, they will issue what is called an ex parte order of protection. This is a temporary order of protection. Judges will grant these liberally because they want to protect victims. After an ex parte order of protection has been issued and the respondent has been served with a copy of that petition, a hearing will be held on the full order of protection. It's kind of like a mini trial. The petitioner has the burden at that trial to set forth evidence and call witnesses to establish and fulfill the statutory requirements necessary for the judge to grant their order of protection. The respondent also has a right to set forth evidence and to call witnesses to rebut the evidence set forth by the petitioner. After all the evidence is put into the record, the judge will make the determination as to whether or not the petitioner has satisfied their burden. If the judge finds that they have, they will grant the order of protection. If they find that they haven't, then the petition will be denied. What's very important that you remember is that you have the right to an attorney at a full order of protection hearing. Whether you're the petitioner or the respondent, you can have an attorney with you to cross-examine the other side or to submit evidence on your behalf. You might be asking yourself, well, why do I care if I get an order of protection granted against me? Well, orders of protection are civil in nature, so much like evictions, they can never be expunged from your record. If the judge grants that order of protection against you, it's going to be on your record forever. And second, and perhaps the biggest reason why you should care, is because if this order of protection that's granted against you deals with a domestic partner, then under federal law, you can never have guns again. You can be prosecuted under federal law for being found in possession of a firearm if you have an order of protection issued against you from a domestic partner, which is why it's even more important that you get an attorney to represent your interests if a domestic partner files a petition for an order of protection against you. I hope this video has been helpful to kind of give you an overview on how orders of protection work in the state of Missouri. If you got any more questions, please feel free to comment down below or to reach out to us directly. Thanks again for tuning in. We're going to be back soon with more videos.